Not in the matter. I say, are you not in the matter? Yes, Mr. Ohatu. Yes. This case is hereby adjourned to 22nd day of January 2026 for cross-examination and continuation of hearing.
As the court pleases.
Between the interconnected trustee of and one, Reverend Joseph Louis Michel. 2, Professor Essende, Chairman Clinical Chapel. Pilot, the first and second defendant report. Salome. That the first and second defendant on the list. No, the claimant in court and the second defendant.
Claimant, is he a human being? Is he a human being?
The claimant is represented by the chairman of the board.
But when the matter was called, he did not stand. What is his name? Appearance. Yes. Are you appearing for who? Appearing with who? Donald Archibald. Abraham. Yes. Yes, any other appearance? Any appearance for the defendant? Yes, where is your lawyer? So the court should wait for him. Yes, leadership.
They have not filed any.
Yes. Yes.
The matter was.
Yes. You can go ahead.
But this is an action. And by way of an alternative sum. Filed on the 20th.
I'm coming. Yes. I have recorded what I asked the defendant. That where is your lawyer? He said my lawyer is on his way. And the court responded that court cannot wait for counsel, as counsel knows that court sits by 9 a.m. and it is now 9:20 a.m. Yes, we can proceed. Yes.
And by an alternative sum.
Yes.
The 20th of August.
File on. Yes.
The alternative sum was filed.
Yes.
Saying this on determining the issues set out. Two issues are set out on the first of the summer.
Yes.
Based on those, the claimant release, 5 release set out in the summer.
Yes.
That summons is supported by an affidavit of 35 paragraphs. One by the legal advisor of the claimant. Affidavit of 23 paragraphs. One by the legal advisor to the claimant.
Yes.
Next to the affidavit, we rely on all of them.
Yes.
My Lord, we rely on the claimant's of employment, which is Exhibit C5.
Yes.
The claimant's conditions of service, the C6,
Yes.
and the constitution of the claimant.
Yes.
Lord, the summons is also supported by a written,
Yes.
which we adopt as our argument in this case.
Yes.
This action is because the contract of employment is determined first.
Can you do that? Can you do that? They are originating somewhat.
According to your lordship, we interpret the provisions of that contract.
Yes.
Yes. And we have highlighted the constitution, the provisions of the contract.
Yes.
The parties are those from the interpretation of this. The defendants are insisting that the tenure of the defendant has been extended.
Okay.
In accordance with the provisions of those contracts.
Okay.
And they are before the law to interpret whether the facts which are not existing in this matter.
Yes.
But we rely on the summary. The argument is and respectfully what you know. Find the prayers on the new state. And
yes,
we also emphasize the fact that the facts in this case are not at all. That is why there has been nothing filed by the defendant to dispute the facts. The only issue is the interpretation of the relevant and undisputed provision of the contract.
yes. 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 You said? Ubi Francis. Inela. Ubi Francis who? INH. You are there for who? Have you filed your memorandum of appearance? Have you filed your memorandum of appearance? Well, we have already had the motion. We have already had the summons, originated summons. And I'm adjourning for adjournment. Well, I have already told you the position of the case. We are adjourning for judgment. Hey, let me see you there. Let me see. When I was 15 January. Huh? 20. 20. 20 is a Tuesday. Okay. Yes, we are just fixing for how many, because from February, we will be sitting until so we have one judgment on 27. Let's get this one. Um, This case is hereby adjourned to 12th of February 2025 for judgment. You know, counsel, they say procrastination is thief of time. So next time, be punctual coming to court. It would have saved you this trouble if you had come in time. Yes, call the next case.
Sorry, my lord, we are supposed to have a judgment. We don't know if the judgment is ready, sir. That is 51-2023. Esther Baron Obi against Chief Gabriel Umodin.
The parties is as to whether that contract will terminate on the 21st of January or not.
Okay.
Yes.
Hey, but
I'm so sorry because this application was on the day before that. Because the goal is to support us to whether the best defenders contract of employment terminate on the 31st of January.
let me see.
My lord, sir, we don't know if the judgment is ready, sir.
As counsel, you don't dictate the court. Am I playing?
Sorry, my lord.
Not you. I'm talking. We are having virtual sitting, and he was trying to say something. You can't dictate to the court. Am I playing here?
No, sorry, my lord. We are not dictating to the court. We thought that the judgment will be the first.
You listen. When we call your case, you announce appearance. Yes, this case is adjourned to 22nd day of January 2026 for judgment. Call the next case.
And Ground Law Limited. My lord, the claimant in court, defendant absent.
Appearance. Yes. 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 EO. Etaba. Okay. OT. ABA. Are we appearing for who? Yes. It's all right. This matter is for judgment. Unfortunately, I have so many things around. I traveled for something, and that did not allow me to finish. But you come back on Monday for the judgment, please. Yes. 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 Yes.
Another one, for this to call
Yes, those applications came up now, but you are not in court, and I have blocked them out. Hey, have you not served him with the virtual hearing notice? Huh? Counsel, why are you denying? In fact, I insisted. They said they called you that time. You say you were somewhere. You can't play like that. You can't play to the court. We have given you. We have served you We don't need to serve you with physical or hard copy. Once we serve you through phone, that's the end. You have given us your phone, we have served you that this water is coming on so date. The Supreme Court has affirmed it. We have served you with hearing notice for those applications. You refuse to appear.
No, sir. Because I was to appear in another court, the High Court, sir. And when I
Counsel, whether you are appearing even before the Supreme Court, you have a duty if you have received that message. If you are not disposed, write to the court. Or you get a junior to come and inform the court that this is what happened. But you ignored the process of the court.
they also called me.
That is even enough. Now you have even confirmed to me that you are aware that those applications are coming. No, you can't. Please, counsel, don't. We have evidence. We have actually, so you can't deny it. There is nothing you can deny in this era of technology. You can't deny it. Once we serve you, it's automatic. You give us the result, and even the time you receive it on your phone or in your email address. So you can't deny it. It's only you choose not to come to court. So I have told you we have struck out those two applications. They are no longer before the court. This case is hereby adjourned to 8th of December 2025 for judgment. You are even okay.
So my LIC flagship at 35/2020 between Chief Celestine Otu Eden
Yes.
and 1, the Nigerian Customs Service Force. 2, the Nigerian Customs Service. 3, the Controller General, Nigerian Customs Service, Consular Command. My Lord, parties are absent.
Appearance. Yes.
With profound humility to this court,
Yes.
I'm MD Tuga, Assistant Chief State Counsel for the
Yes.
defendants.
Assistant Chief.
Chief State Counsel, my lord, for the defendants.
The defendants, they are online. You know, this matter was adjourned both for virtual and physical. So anyone that chooses to appear virtually can appear. So the defendant is appearing virtually. This matter is for judgment.
Yes, my lord.
Read the judgment. Yes, this is the judgment of the court. On the 27th day of November 2020, the claimant took out a general form of complaint accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on, and photocopies of documents to be tendered in evidence. The claimant's claim against the defendant are as follows. 1, a declaration that the defendant's failure or refusal to pay claimant pension and gratuity after 27 years of service amount to a constitutional breach of the claimant's right pursuant to Section 173 of the 1999 Constitution of the Federal Republic of Nigeria and Civil Service Rules. 2, a declaration that the purported termination of claimant's appointment by the defendant without strict compliance with the provision of civil service rules that regulate claimant's appointment with the defendant is wrongful, illegal, null, and void. 3, a declaration that the arrest and detention of the claimant for 3 months, suspension without payment for 2 years, and the demotion from the rank of DSC GL09 to GL07 without hearing is a breach of constitutional rights. 4, a declaration that the defendant conduct by transferring a suspected drugs traffickers from Murtala Mohammed Airport to operational cells of the Federal Operation Unit Armored to aid the escape is criminal act or responsibility which cannot be transferred to the claimant. 5, a declaration that the defendant's conduct by transferring suspect drug traffickers from Murtala Mohammed International Airport to Amore containing 87 Mark IV rifles and live ammunition and marked guards and armed guards to prevent their escape was a criminal conspiracy aimed at aiding the escape of the drug traffickers, which cannot be transferred to the claimant. 6, an order on the defendant to pay the claimant his withheld salaries for the period of suspension and balance of his withheld salaries from the period of demotion in the rank to his retirement. 7, an order on the defendant to compute and pay claimant's pension and gratuity from year 1996 to date at the present rate to reflect 1992 promotion from DSC to SC, which was wrongfully withheld. 8, an order on the defendant to release the claimant's promotional examination result from the rank of DSC to SC conducted in 1992. 9, 50 million damages for various acts of breach of claimant's right and inhuman treatment meted against him by the defendant. The defendant, upon being served with the originating process on the 22nd day of February, filed memorandum of conditional appearance. This was followed by an application challenging the competency of the suit on the ground that it is statute barred. The preliminary objection was argued and the ruling was delivered on the 30th day of March 2022. On the 3rd of March 2022, the defendant filed their statement of defense. On the 28th day of May 2024, the defendant filed an amended statement of defense. In response to the claimant, on the 2nd day of July 2024, filed a reply to the statement of defense. On 1st of November 2022, the claimant opened his case and testified as CW1. CW1 tendered documents in evidence. They were admitted in evidence and marked as Exhibit A to N. On the 30th day of October 2024, CW1 continued with evidence in chief and tendered 2 additional documents in evidence which were marked as Exhibit O and P, respectively. CW1 concluded his evidence in chief. He was cross-examined by the counsel for the defendant. Thereafter, was discharged. On the 28th day of January 2025, the defendant called one AE Takon, DSP, who testified as DW1 in proof of the defense of the defendant. No documents were tendered by the defendant in evidence. On the 19th day of March 2025, DW1 was cross-examined by counsel for the claimant. At the end, he was discharged. The case of the claimant. Counsel, to save time, I will skip reading the case of the claimant. I will also skip reading the case of the defendant, as well as the reply filed therein. I will also skip reading the submissions his submission, the defendant formulated a single issue. Argument has been captured irrespective of the issue in the body of the judgment. The claimant formulated twin issues. The argument on the issues have been captured in the body of the judgment, so I will skip reading those arguments. I go straight to the decision of the court. I have considered the processes filed by the parties, the evidence laid at the trial, and the exhibit tendered in evidence by the claimant. I have equally considered the final written addresses of counsel for the parties, as well as the oral submission in adumberation. There is no doubt the ruling of this court delivered on the 30th day of March 2022 on the preliminary objection of the defendant has circumscribed the scope of the issues to be considered in this judgment. For avoidance of doubt, the ruling of 30th day of March 2022 found that apart from relief 1 and 7, which are on pension, all other reliefs were caught by the doctrine of statute bar, and they were accordingly dismissed. This means that this court can only delve into the issue of pension, entitlement of pension of the claimant. The court has become factus officio in respect of claims bordering on termination, arrears of salaries, arrest and detention of the claimant, and also the issue of his promotion. In view of the foregoing, the issue calling for resolution is whether the claimant has proved the entitlement to reliefs 1 and 7, as contained in the complaint, in the statement of facts. The law remains that he who asserts has the onus of proving his assertion. In civil cases like in the present case, the burden is on the party who assert a fact to prove the same. That is the claimant in this case. In other words, the burden of proof lies on the party against whom judgment of the court will be given. If no more evidence were adduced successfully until all the facts in the pleadings have been dealt with, the burden of proof is on the party who alleges the affirmative. That is the claimant in this case. This means that the burden of proof is on the claimant who will fail if no evidence is laid in the case. A party who pleads and asserts a fact bears the burden of proving same. That's why the claimant in this case, who pleads that he is entitled to pension and gratuity for 27 years, he served the defendant bore the burden of establishing his claim by adducing credible evidence in proof. See the case of Mbukutu versus Abo. See also Osauru versus Ezerenka. See also Oduakwe versus Ogumbi. See also Corporate Ideas Institution Limited versus Ajakuta Steel Company Limited. See also Dakachi of Gere versus Dakachi of Ebwa, and host of other cases cited therein. While the general burden of proof in civil cases rests or lies entirely on the claimant, such burden is not static. As the matter progresses, such burden may be foisted on the defendant to call witnesses in proof or rebuttal of some particular point arising at the trial. This is to say, the burden shifts from one side to the other as the pendulum shifts. See the case of Abiodun versus Adehin. See also Imana versus Robinson. So see also Inorodin versus Ediani. See also Palogi versus Test Impression Cleaners Limited. It is clear from the facts and evidence before the court, there is no dispute that the claimants served in the Nigerian Customs Service for a period of 27 years, i.e. from 1969 to 1996, when his employment was terminated by the Exhibit K, letter dated 13th day of June 1996. The claimant in his pleading and evidence stated that in his appointment being pensionable, he is entitled to pension since he had served the dependent for 27 years. The relevant provisions of the claimant's pleading on his claim on entitlement to pension are hereby reproduced for clarity. I reproduce paragraphs 4, 23, 32, 33, 34 of the statement of facts. Therefore, I will not read them. I will skip reading them, but I have reproduced them in the body of the document. It is clear from the pleadings of the claimant that his appointment was governed by the provisions of 1990, and according to the claimant, he stated that his appointment was governed by the provisions of 1990 and 1999 civil service rules, revised edition. The claimant maintained that his pension was guaranteed by the Constitution and civil service rules, but he has not referred this court to the relevant specific provisions of the civil service rules applicable to him or his entitlement to his claim for pension. From the defendants, for the dependent, they admitted that the claimant was employed by the defendant to serve for 35 years or approaching 60 years of age, whichever comes first. They have also admitted that the claimant served the defendant for 27 years. But during the period of service, the claimant earned himself suspension from service and even demotion or rank before his appointment was subsequently duly terminated in line with the civil service rules and the Constitution. However, the defendants have also, like the claimant, did not refer this court to the relevant specific provisions of the civil service rules or provisions of the Constitution, which they have complied with in the suspension, demotion, and termination of the claimant and subsequent termination of the claimant's employment. In clarifying the reason for demotion of the claimant to lower rank and why claimant is not entitled to pension and gratuity, the defendants made some abatement in his pleadings, and those pleadings that are relevant to the issue are hereby reproduced also for clarity. They are, I have reproduced paragraphs 8, 9, 10, 11, 12, 13, 14, 16, and 17, 18, 20, 21, 23, and 24 of the statement of defense. It is clear from the pleadings of the parties that the claimant is insisting on entitlement to be paid pension for service rendered to the defendant for 27 years, while the defendant is of the view that the claimant is not entitled the claimant is not entitled to succeed in his case as he has not proved entitlement to pension. It is regrettable that none of the counsel for the parties have emphatically made references to specific provisions of the public service rules relevant to the claimant's case wherein pension was granted. However, in my view, the court can by law take judicial notice of all relevant laws and subsidiary legislation applicable to the claimant's claim for pension. However, the facts applicable to the laws to be judicially noticed are within the province of the claimant. Those facts have to be adduced by the claimant. This means the claimant must, by his pleading, state the facts based on which the laws to be judicially noticed apply. There is no doubt from the facts as disclosed by the pleading, the claimant served the defendant from 1969 to 1996 by virtue of the provisions of Section 8, subsection 1 of the Nigerian Customs Service Board Act. The law establishing the first defendant, in this case, the claimant service or appointment, was pensionable. Therefore, the relevant civil service rules that govern payment of pension applicable to the claimant is the 1974 Civil Service Rules, which was subsequently amended. The appropriate applicable pension law as to the time as at the time the claimant's appointment was determined by the defendant was the Pension Act number 102 of 1979, now Pension Act Cap 346, Laws of the Federation 1990. It is equally important to note that Pension Act Cap 346 of 1990 has been repealed by the Pension Reforms Act of 2004 and subsequently by Pension Reforms Act of 2014, which is now the extant act on pension in Nigeria. The major difference between the pension laws is that under the old scheme, Pension Act of 1990, Cap 346, is not based on contribution to the pension claim. It is a defined scheme, like the case with Pension Reform Act of 2004 and subsequently 2014. As pointed out above, the Pension Act Cap 346 applies to the claimant as it applies to employment in the public service of the Federation. See Section 83, sub 83 and 4 of the Nigerian Customs Service. Let me state here that pension right is one that an employee has and must enjoy if there are no just of case law authorities on this point. For instance, by the decision in the case of Momodu versus Nulge, the Court of Appeal has stated that a pension is an accrued right of an employee, a right in money or other consideration, or retiring from service of his employer and satisfying the condition for payment of the said pension. It is a right which cannot be unilaterally taken away by the employer. See also NEPA by NEPA and against Adeyemi versus Adeyemi, where it was held that entitlement to pension and gratuity is vested right, and whether an employee is eligible for pension and gratuity can be decided only by reference to the condition of service, and by the decision in the case of RLCE versus Omobo. In a pensionable employment, the employee's right to pension remains in the year of his retirement. Until then, that right is only contingent upon attaining his age of retirement. Going by the provisions of the Act, that is Cap 346, for the claimant to qualify to be eligible for payment of pension, he has to show that he served the dependent for a period of 15 years, but the payment of pension shall not commence until such officer has attained the age of 45 years of age, or had attained the age of 60 years of age to be able to qualify for pension under the Act. Or he was compulsorily retired due to medical unfitness, public interest, or organizational restructuring. See Section 3 of the Pension Act, Cap 346, Laws of the Federation 1990. The claimant has shown that in this case, the claimant has shown that he served the dependent for a period of 27 years, which has been admitted by the dependent when his appointment was terminated. What is clear is that the Pension Act 3, Cap 346 is not an all-comers law. It applies only to employees of the public service of the Federation. The claimant in the instant case is an employee of the public service of the Federation and so eligible and entitled to claim benefit under Cap 346/1990. However, the defendants have insisted that the claimant is not entitled to pension because he did not retire from service. A careful perusal of the facts leading to the taking of disciplinary action by the defendant against the claimant will clearly show that the defendants have, by demoting the claimant, disciplined the claimant on the alleged escape of the hard drug suspect when the claimant was on duty. Therefore, the subsequent termination of claimant's appointment as per Exhibit K cannot be said to be termination based on misconduct, as he cannot be punished twice for the same offense. This on the same fact. This means claimant's appointment was terminated not based on misconduct, and that cannot serve as a cloak to prevent the claimant from entitlement to accessing his pension. It is pertinent to state that applying the purposeful and holistic interpretation of provisions of statute by Section 24 of the Pension Act as it relates to issue of termination in relation to an officer's service, it means termination of service by retirement or withdrawal. Given this definition, therefore, the termination of claimant's appointment employment by the defendants would mean termination of service by retirement or withdrawal. However, by Atinubu versus Minister of FCT, it was held that by virtue of Section 32A, B, 4, and C of the Pension Act, Cap 346, for a public servant to qualify for pension, he must have been in the service for 15 years and aged 45 years at the time of his retirement. In the case at hand, there is no doubt claimant has satisfied the requirement being on pensionable age. The fact of having attained 27 years in service is more than sufficient. The claimant has, in his pleading, stated that his appointment was pensionable, which has not been contradicted, a prerequisite to recovery under the pension law. However, Section 332C of the Pension Act of 346/1990 provides that an officer retiring under Section 31, if he is required to retire after 15 years qualifying service pursuant to the provisions of Section 316, 1C to H, he shall be entitled to pension immediately or retirement, notwithstanding that he has not attained the age of 45 years. By this provision, the requirement of age at 45 years, as enjoined by Achimugu versus FCT, as the prerequisite for recovery of pension under the Pension Act Cap 346, appears to have been waived. The evidence before the court clearly shows that the claimant served the dependent for 27 years. This means since the claimant is an employee in the public service of the Federation, he is duly entitled to his claim as per the Pension Act 346/1990, since it was the law applicable at the time his employment was terminated by the dependent as at 1996. On the whole, the claimant is entitled to pension for 27 years. He had served the dependent. However, with the coming into force of Pension Reform Act, the payment of pension for all eligible pensioners under the old scheme of Pension Act Cap 346 has been transferred to Pension Transitional Committee PTDA established under the 2014 Pension Reforms Act. This means that the success of claimant is only a result of pension due to the claimant from 13th day of January 1969 when he joined the service of the dependent to 20th day of June 1996 when claimant's service was terminated as per Exhibit K. Upon the commencement of the Pension Reforms Act 2004, upon the commencement of the Pension Reform Act 2004 and subsequent amendment of 2014, the old defined benefit pension scheme under Cap 346 for public service employee was effectively phased out for new entrants into the public service. This means that any individual who joined the public service from June 2025, 2004 onward automatically becomes a participant in the contributory pension scheme. The primary, however, for public servants who are already in the service before the commencement of the Pension Reform Act, like the case of the claimant under the old defined benefit known as accrued pension right, their pension were still preserved under the law, and they are entitled to continue to receive their pension from the federal government. The Pension Reform Act clearly stipulates that for employees in the public service will continue to receive their pension under the old system to be paid by the government. Therefore, the responsibility for continuing with the payment of these old pension liabilities, specifically the accrued right, is primarily vested in the federal government for its employees. Section 39 of the Pension Reform Act 24 outlines the funding mechanism for this accrued right for federal government employees like the claimant in this case. In essence, what this means is that by the Pension Reform Act, the old pension scheme ceased to admit new members, but the liabilities for existing public servants, like the claimant, were not extinguished. Instead, they were converted into accrued rights, and they will continue to receive their pension as provided by the government. However, that pension is no longer to be paid by the dependent in this case, and the claimant has not joined the relevant party that's supposed to continue with the payment of his pension. The circumstances, and even there is no prayer for the continuance of payment of his pension. His only prayer was that he be declared that he is entitled to receive his pension and for his pension to be computed and paid up to date. Therefore, the up-to-date pension is from 13th of January 1969 to 20th June 1996 and no more. However, from all I have been saying above, the claimant has been able to prove that he is entitled to relief one. He has proved that he is entitled to relief one. That is the declaration that the refusal to pay his pension by the dependent a declaration that the claimant is also entitled to relief one, that is pray and order the sorry, I have let me correct. The claimant has succeeded in establishing entitlement to grant of relief one, a declaration that the failure or refusal to pay claimants pension and gratuity after 27 years of service amount to a constitutional breach of the claimant rights pursuant to Section 173 of the Constitution of the Federal Republic of Nigeria, 1979, and not 1999, as stated by the claimant, as the applicable constitution when the claimant's employment was terminated was the 1979 Constitution and not 1999 Constitution. Having granted relief one declaration that claimant is entitled to grant of his pension, relief seven, which is praying for an order directing the dependent to compute and pay claimant's pension and gratuity, also succeed. However, but this said gratuity to be calculated or computed shall be from 13th day of January 1969 to 25th day of June, the day his 1996, the day his employment was terminated. Relief 6 is an ancillary relief dependent on grant of relief 1. Having granted relief 1, the ancillary claim must also succeed. This is because generally the courts are bound to only grant relief that were sought if proved and the order for computation was granted because it is an ancillary relief that has to go with the declaration. Having made the declaration, the court must also make an order to give effect to the declaration. The dependent being former employer, the defendant being a former employer of the claimant is usually in the best position to carry out such computation as they possess all the necessary records pertaining to the claimant's employment, the salary applicable, and the pension scheme's yardstick for such calculation. Therefore, directing the dependent to compute is in the right direction and to give effect to the primary relief of declaration. However, such computation has to be done in line with the provisions of the Pension Act Cap 346 of 1990. In view of the foregoing, the dependents are hereby ordered to compute and pay the claimant his pension entitlement as for the service rendered for the 27 years service rendered to the dependent. Taking into consideration the facts as disclosed in this case, I make no order as to cause. Judgment entered accordingly.
As the court pleases. We are grateful, my lord.
You are welcome. Yes, call the next case. Yes, counsel, you are free to go.
Yes, my lord.
And Chief Gabriel Umodem.
You are free to go.
Thank you, my lord.
My lord, the defendant absent.
Appearance. Appearance. Are parties online?
Lord
Yes,
A.G.
counsel,
Robert.
announce your appearance. Unmute yourself.
A.G. Robert, Esquire, for the defendant, my
Unmute
lord.
yourself. Who?
A.G. Robert, Esquire, for the defendant.
Please talk loud. I'm not hearing you.
A.G. Robert, Esquire, for the defendant, my lord.
Counsel, talk louder.
A.G. Robert.
I did not hear you.
My lord,
Okay,
A.G.
A.G.
Robert, for the defendant, my lord.
Yes, appearing for who?
The defendant.
Any other appearance? Yes. Any other appearance? Is
My
the
lord,
counsel for the claimant not online?
Austin Okeja usually appears for the claimant.
Yes, unmute yourself and who?
My lord, Austin Okeja usually
Who
appears for the claimant. Austin Okeja.
Okay, he is not online. I'll record the claimant counsel absent. This matter
As
is
the
for
court
judgment. Yes, this is the judgment of the court. Please, I'm sorry, there is mix up in my seeing some things that are not. Counsel, Mr. Roberts. Mr. Roberts, unmute yourself.
Yes, my lord, I can hear you.
Please, I am seeing some mix up in my judgment here. So please, just give me till tomorrow. I'll sort out after I finish it, and then I will deliver the judgment tomorrow.
As the court, please. We are most grateful, sir.
You are welcome. The judgment will be delivered on 3rd of December 2025.
As the court pleases.
Number NIC that is 2025. And 25 others between themselves and as representative retired state auditors. And one, government of Cross River State, Attorney General of Cross River State. 3, Accountant General of Cross River State. 4, Auditor General of Cross River State. 5, Head of Service, Cross River State. My lord, parties are absent.
Appearance. 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 No appearance. Are the defendant from ministry? Yeah, but where is the what do you call her? Where is Victoria? Eh? I have told her what to do concerning all the cases involved. Why is she fixing them for today? Call her. I have told her what to do with these cases. I even say she should call the council and tell them that there is a letter from ministry. These cases that involve this letter, I leave the matter for today. You should adjourn them since they requested for both days. I sent the letter to you, and I said you should, since I even asked you how many cases they have. Adjourn them till next week and serve them with hearing notice. What date are we going to fix this one? Okay? This case is adjourned to 10th of December 2025 for ruling. This one too available. Call the case.
By NIC that 2025, between one, Dr. John F. Kano, two, Dr. Emin Matu, three, Dr. Iba Innocent Sheikh, four, Dr. Ubi Umi, five, Dr. Sivanus Badi Abi, six, Ekbe Lawson Eden Paul, seven, Okoro Elido Michigan, eight, Francis Agede, nine, Kingsley Itam Okon, 10, Suleiman Benga Lawal, and one, academic staff Union University, as two, Professor Peter Ubi and Romanus Agua for themselves and on behalf of the academic staff Union of University of Calabar branch. My Lord,
Yes.
my Lord, the second, third, and 10th claimant absent in court. Then the first defendant represented by Sanusi. Your position, sir. The second defendant, sir, your name. Okay,
Hey, what happened? You have not finished calling the parties.
Dr. John J. Edo.
Appearance. Yes. Yes. Are you for whom? Yes. 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 The issue is when they said virtual is we gave you choice. You can decide to come physically. You may decide to stay in your office and join us. That's what it means. We gave you choice.
So tomorrow, if I choose to stay in the office,
Yes, yes,
if I choose to come here,
yes, yes. It's all right. This matter is for ruling. This deal with motion on notice brought pursuant to Order 22, Rule 1 of the National Industrial Code Civil Procedure Rules 2017 and under the inherent jurisdiction of the court, wherein the claimants applicants are praying for an order of interlocutory injunction restraining the first and second defendants, whether by themselves, their agent, previous organs, or howsoever otherwise called, from further harassing, intimidating, threatening, suspending, or in any way interfering with the rights, privileges, and entitlement of the claimants as members of the Academic Staff Union of Universities ASU, University of Calabar branch, pending the hearing and determination of this suit. To an order of interlocutory injunction restraining the second defendant, his officers, servant, agent, previous, or howsoever called, from remitting, transferring, or paying any part of the claimant's second use to the first defendant, whether for the period covering August 2019 to October 2023, or for any other period pending the hearing and final determination of this suit, and for such further or other orders as this honorable court may deem fit to make in the circumstances. The application is supported by a 38 paragraphs affidavit sworn to by the first claimant himself. In line with the rules of this court, a written address was filed along with the motion on notice. In arguing in support of the application, Samuel Ekpeme Esquire, counsel for the claimant's applicants, informed the court that he is relying on the depositions in the affidavit in support of the motion on notice and also adopted the written address filed along with the motion as his argument. In opposing the application, the first and second defendant filed a counter affidavit of 45 paragraphs sworn to by Professor Igwenyi Ikochukwu Okori, Esquire, zonal coordinator of the first defendant, Christian C. Chukwu Esquire, counsel for the first and second defendant, in oral adjudication. In oral submissions in opposition to the application relied on the amendments in the counter affidavit. Counsel also adopted the written address as his argument. In the written address, in support of the motion on notice, a single issue was formulated for determination to wit whether this honorable court can exercise its discretion in favor of the claimant and grants the application as prayed. Counsel commenced argument by making reference to Order 22, Rule 1 of the rules of this court. Counsel also submitted that this court draws its power to grant an injunction based on Order 22, Rule 1. It is submission of counsel that injunction, being equitable remedy, is not granted as of right or as a matter of course, but upon sufficient cause given for the court to exercise its discretionary power in favor of the application. It is only where the court grants an injunction upon sufficient grounds that it is said to have exercised its discretion judicially and judiciously. In support of this contention, reliance was placed on the case of Owodumi versus Registered Trustees of Celestian Church. Council also submitted that the grant of interlocutory injunction is to preserve the rest and prevent irreparable harm pending the determination of the substantive suit. On this, council relied on the case of Kotoe versus CBN, where conditions for grant of interlocutory injunction were stated. Council also refers to the case of Obeya Memorial Hospital versus Attorney General of the Federation. Council submitted that an injunction to be granted, the substantive suit must raise substantial issue of law for the court to determine. There should also be balance of convenience in favor of the applicant. The applicant will also suffer an irreparable injury if the injunction is not granted, as well as rendering the judgment of the court immediately. That the injunction being an equitable remedy, the applicant must approach the court with clean heart, and the applicant in this case has approached this court without any blemish. It is submission of counsel that bringing the above, bearing in mind the above authorities, the claimants have satisfied the condition for grant of interlocutory injunction. For the defendant, the respondent, they also formulated a single issue for determination whether it is justifiable for the Honorable Court to exercise its discretion in favor of the claimant in the circumstances of this case. In arguing the sole issue, counsel answers the above issue in the negative by submitting that the law is settled that in granting this kind of injunction and application, the court normally consider whether there is a genuine reason upon which the application is made, and not by facts founded on merely speculation or sentiment. On this submission, reliance was placed on the case of Yesiku versus Cooperative Bank. It is also submitted that the claimant applicant has not disclosed any genuine reason or recognized legal right that meet the protection of the court by way of interlocutory injunction. The law is settled that the onus is on the applicant for the injunction to establish that he has a recognized legal right in the rest. The court has no power to grant injunction where the applicant has not established legal right in support of his contention. Counsel relied on the case of Lafia G Nigeria Limited versus Nan Merchant Bank PLC. It is further submitted that all the relief sought by the claimants in this motion are the same relief they are seeking in the substantive suit pending before the court. The claimants are seeking for an order of interlocutory injunction on the issues concerning suspension of the second dependent and remission of Jacob dues, which are the main issues the claimants are contesting in the substantive suit before the court. Counsel refers to the case of Agu versus Julius Berger, where it was stated that when determining an interlocutory application where the praise overlap with the substantive claim, it is safer to refuse such application and order for the hearing of substantive matter. Counsel asked the court to so hold. It is tried to know that at the interlocutory stage, the court is not allowed to delve into the substantive matter in the pending matter and decide it. On this, counsel refers to the case of Globe Fishing Industries Limited versus Coca. He also referred to the case of Bonayas versus Other Farm Nigeria Limited. It is also submitted that the suspension, which the claimant are seeking interlocutory injunction to restrain the defendant from imposing is giving effect to had already been issued and imposed before the filing of this suit. Therefore, the claimant are not entitled to interlocutory injunction. It is a tried law. According to counsel, it is tried law that interlocutory injunction cannot be issued for an act that has been completed. In support of this submission, counsel referred to the case of Laperi Nigeria Limited versus Nal Merchant Bank Supra. Counsel also submitted that where the allegation of crime are made in a matter before the court, such allegation of criminal allegation must be proved with reasonable particulars. It is not enough for a party to make an allegation before the court. He must lead credible evidence to prove them. To support this view, reliance was placed on the case of Union Bank PLC versus Astra Builders Limited. Counsel asked the court to discountenance those paragraphs of the affidavit of the applicant. In concluding his submission, counsel asked the court to grant not to grant the relief sought and refuse the interlocutory injunction. Court decision. I have carefully and painstakingly perused the motion on notice, the affidavit in support, the counter affidavit filed by the first and second defendant, and the entire case file containing the processes so far filed in this suit. I have equally examined the written and oral submissions of counsel for the parties in adumbrration of the respective position of the applicant. From the processes filed, the issue calling for resolution in this application is whether from the facts as disclosed by the affidavit and pleadings of the claimant is entitled the grant of an order of interlocutory injunction. An interlocutory injunction is a temporary order granted by the court to preserve the res subject matter of dispute or maintain the status quo pending the determination of the substantive suit. Its primary purpose is to prevent irreparable harm or mischief that might occur before the legal rights of the parties can be finally determined by the court. That's why courts are enjoined not to delve into the substantive issues at the interlocutory stage of the case. This is to avoid prejudicing or preempting the final judgment of the court. In the circumstances, I shall not, in the course of considering this application, do anything that will amount to delving into the substantial issues before the court. The power of this court to grant an order of interlocutory injunction is provided for under Section 16 of the National Industrial Court Act and Order 22 of the rules of this court. This court is empowered to grant or refuse an injunction. The power has to be exercised judicially and judiciously, taking into consideration justice of the case. In an application seeking for a grant of an order of interlocutory injunction, the fundamental principles guiding courts of law is that such an injunction is primarily a prohibitory order designed to prevent a party from doing something or continuing to do something, thereby preserving the status ante bellum pending the determination of the substantive suit. It is generally not granted to undo an act that has already been completed. The guiding principles for grant of interlocutory injunction generally requires the applicant to establish prima facie case to demonstrate that the balance of convenience is in his favor and show that damages will not be an adequate remedy for the harm suffered. These principles were reiterated in the case in decided cases such as Union Home Saving Limited versus Chiaza and Onyesho versus Inebedom, and also Farouk and another versus Munkela and another. The proper attitude of the court while entertaining such an application is to avoid delving into the merit of the substantive suit, as pointed out earlier. This is supported by the case of Florence Olabi Enterprises Limited versus Wema Bank Limited. Crucial. It is pertinent to note that concerning or regarding completed acts, the Supreme Court of Nigeria has consistently held that an interlocutory injunction cannot be granted against an act that had already been concluded. As the purpose of interlocutory injunction is to prevent a certain wrong or the continuation of existing wrong, not to reverse or undo what has already been done. This position was articulated in the case of John Holt Nigeria Limited versus Holt Africa Workers Union Nigeria and Cameroon, where the court considered whether an interlocutory injunction could be granted against completed act. The rationale is that if an act that has been completed, there is nothing left to restrain or prevent. Granting an injunction in such a circumstance would be a futile exercise and would amount to a mandatory injunction, which is a typical injunction that is granted after a full trial and not at interlocutory stage, except in any rare and exceptional circumstances where the case is clear and unambiguous. In the case at hand, the first defendant has already suspended the second defendant. Therefore, the suspension has been completed. It's an act that has been completed. And therefore, going by the decision of the Supreme Court in the whole case, this court cannot grant an injunction to reverse or undo what has already been completed. Therefore, if an act complained of has been fully executed before the application for an interlocutory injunction is heard, the court will generally not be right to grant such an injunction. The court's power to grant an injunction, even under just and convenience standard, is exercised to maintain the status quo, which implies preventing further damage, not reversing past damages. If the application seeks to reverse a completed act, their proper response would typically be to pursue the substantive claim to judgment or for a mandatory injunction on the final judgment, which compels a party to perform a positive act, such as undoing what he has already done. An interlocutory prohibit nature looks to the future and not to the past. Therefore, this court is not in a proper position, is not in the proper venue to grant an order of injunction to reverse the already completed suspension of the second defendant. The Appeals Court has consistently held an application for an order of interlocutory injunction must specify certain conditions for such an order to be granted as established in the cases of Saraki versus Kotoye and Saraki versus Kotoye and Obeya Memorial Estate Hospital versus Attorney General of the Federation. In these cases, the court considered the issue of serious question to be tried, balance of convenience, irreparable harm, undertaking as to damages. Let me say here that these conditions or criteria, particularly the requirement for irreparable harm and the inadequacy of damages, underscore the temporary and protective nature of an interlocutory injunction. The relief sought at this stage is typically to prevent the specific action or to compel specific inaction that would prejudice the applicant's position before the final determination of the substantive action. However, it is not to obtain the final judgment itself. Therefore, any determination that will involve the substantive substantive suit must be deprecated. In the case at hand, the peer of the claimant applicant is on the dependents, compelling the dependent to pay 61% of check-on dues, which claimant applicant alleged they have paid already, but misappropriated by the third defendant in this case. So if a second payment of same amount is made, the said payment would have been made twice. Such harm of making double payment be monetary in nature cannot be said to be not to be adequately compensated by way of damages. In view of this finding, I am of the view that claimants applicant have not made out a case for grant of an interlocutory injunction, as the reliefs being sought are reliefs that can adequately be compensated by way of damages. And also, if the court is to delve into the issue on legality of compelling the claimants to pay the amount which they claim they have already paid, it will amount to determining the substantive suit. In the circumstances of this case, interlocutory injunction is not an appropriate order to be made. The appropriate order is to order accelerated hearing, and I hereby order accelerated hearing of this suit. Ruling is entered accordingly. Yes, I will give you. How many witnesses do you have? Okay, Mr. How many witnesses? Mr. Ekuri, how many witnesses do you have? Mr. Ekuri, are you sleeping?
Oh, yeah, sorry, my lord. I was remind my lady to the late provision, please.
Okay, I will give you 3 days. What I said, I will give you 3 days. Whatever we are doing, we must finish the case within those 3 days. Check.
29.
Hmm? 27,
28,
28,
29.
and 29. This case is hereby adjourned to 27, 28, and 29th of January 2026 for hearing. Have we finished with the ruling and
Yes, ma'am.
yeah?
Yes, ma'am.
Well, the next case.
Between Peter Okonta